Good afternoon and welcome to Internet Infrastructure Issues. Welcome to our fourth installment of Internet Infrastructure Issues Business Interruption coverage. I'm joined by Gregory Regal in our Tyson's Corner office, home to Data Center Alley, currently consuming over a gigawatt of energy. Gregory, today's presentation is a little bit different, right?
Dale, it is, and thank you, and I'll join you in welcoming everyone on behalf of the law firm. And as Dale alluded to, while this is one in a series of topical presentations we've done for our clients and friends in the data center industry, this one does reach a little broader and shows, I think, the depth and breadth of business issues that the COVID-19 crisis generates. And certainly as a firm, we have leaned very hard into the full spectrum of those issues, and I think fairly stated this is indicative of that. And I was very pleased to see among those in attendance are a very diverse group of folks that include, again, our friends in the data center industry and folks with a number of other business backgrounds. So I join Dale in welcoming all of you, and I think you'll find this interesting and hopefully entertaining. Thank you.
Gregory, thanks a lot. I agree with you. It's a good time to be in the data center space, but today's a little bit different because it's not just about data centers and it's not just about internet infrastructure. But I want to ask the listeners for just a minute, use your imagination. The year is 2019. You're building facilities. You're adding new employees. You have a plan for the future, and that future is bright. Every morning you pull into your parking space, and you're eager to get back to work because you're getting ready to add new jobs. You're getting ready to put money into the U.S. economy, and that's a good thing. That's a really good thing. And then an event occurs. Maybe it's a global pandemic. Maybe it's a riot or an earthquake or maybe a power outage, and then suddenly you have not only property damage, but also a loss of income. You're dealing with lost time, lost revenue, lost hours, lost sales. If you're an insurer working through coverage issues, or maybe you're the holder of a policy with business interruption coverage, you have some very difficult decisions to make, and those decisions have to be based on facts. Our speakers today are going to help you understand the current state of business interruption coverage, the key issues for decision makers, and some really practical tips on how you can work through those issues. In our first three installments, we've introduced some real practical suggestions for environmental health and safety with some free tools for understanding and managing clean water resources in the data center industry, an industry that's increasingly focused on resiliency, that's increasingly focused on environmental sustainability. And if you missed them, those discussions are available for download at the McGuire Woods Data Center webpage. Now, we have guests and not sponsors, but from time to time we introduce some resources for understanding the complicated world of internet infrastructure. Our guests today have some resources that you should know about, and we'll provide those details at the end. But before we get started, I'd like to take a minute to introduce you to an internet infrastructure resource that's like no other. It's called Interglobix. Interglobix provides global consultancy services to data center, subsea, and terrestrial fiber companies with some of the biggest clients in the industry. My favorite is the Interglobix magazine. That magazine publishes a high-quality content that's a great tool to be used as a reference guide. About 90% of the content is written by leaders in the internet infrastructure industry. And I'm happy to say that in the upcoming anniversary issue, McGuire Woods will feature some exclusive legal content to help explain some of the most pressing legal issues in the internet infrastructure industry. You can find them at www.interglobix.com. Before we get started, I'd like to alert you to a feature of the On24 system. In your presentation manager, as a participant, you have the opportunity to pose questions. Along the bottom bar of your screen, you'll see a Q&A section. And in that Q&A section, please feel free to pose questions to our guests this afternoon. and we will get to those at the end of the presentation, or I'll make an opportunity in between if it seems appropriate. So for today, I'm pleased to announce that we have Ann Dorsett. Ann Dorsett is counsel for McGuire Woods in Charlotte, North Carolina. She's been engaged in insurance coverage and claims counseling for over 3 decades. Ann's background includes litigation and complex insurance coverage disputes, including products liability, property damage claims, and most recently, claims made under representation and warranty insurance policies. Ann routinely counsels clients in the presentation of claims and assists clients in the review of insurance programs, the sufficiency of coverage under those programs, and negotiation of policies at renewal. I'm also pleased to announce Matt Fender is here with us today. Matt Fender is a trial lawyer and a commercial litigator who focuses on insurance recovery for policyholders. He's a veteran of the technology sector, and prior to attending law school, he worked heavily in that industry. He represents clients on insurance coverage disputes from the initial claim through trial or arbitration. Good afternoon, Ann. And Matt, good afternoon to you.
Good afternoon, Dale.
Good afternoon.
We're going to start with Stephen Foresta. Stephen is a litigation partner in our New York City office and focuses his practice on complex commercial litigation. Stephen's focus is an emphasis on representation of policy owners in high-stakes insurance recovery matters. He's litigated a wide variety of coverage claims, including general liability, mass tort and product liability, environmental cleanup, E&O, contingent business interruptions, construction defects, data breach, and cybersecurity claims. And over the course of his 30-plus years in the career, he's recovered more than $1 billion in insurance proceeds on behalf of policyholder clients. Stephen, let's start this off today. Good afternoon.
Oh, great. Thanks, Dale. That's quite an introduction, and I appreciate you and Greg inviting me and Matt and Ann to come here and talk about insurance issues. It's our pleasure to be here, and I want to welcome everyone in the audience and wish you a good evening, a good afternoon, or a good morning, depending on where you are. The title for this presentation, COVID-19 Business Interruption Coverage, is a little bit of a misnomer. Certainly, we're going to focus our principal discussions today on the coronavirus and on business interruption issues. We're going to go a little broader than that and talk about some other potential coverages that might apply to businesses that are damaged by COVID-19. And I think more generally, the topics we're going to discuss today go even beyond damages, losses that are incurred as a result of the coronavirus, and in many respects apply generally to businesses. And I know this is a program focusing on data centers, and clearly the issues we're going to talk about today are impacting your industry, but even for those of you who are not in that space, I think the topics we're going to talk about today will apply to you as well. And I'm hoping that you'll take away some key points that we want to emphasize today. And as Dale said, there'll be an opportunity at the end to pose some questions to us that we'd be happy to answer for you. Before we launch into the presentation, I want to give you a little bit of a preview of what we're going to talk about today. I'm sure by now I don't need to tell any one of you about the enormous impact that COVID-19 has had on the U.S. economy, on the global economy. Businesses in every industry imaginable have been affected by the coronavirus. Particularly hard hit, of course, are businesses like hotels, restaurants, entertainment venues that have been either directly closed or effectively closed. by state and local government ordinances. These businesses have suffered enormous economic losses, but the losses extend certainly beyond those industries as well. Not surprisingly, for these businesses that have incurred business-related losses as a result of COVID-19, they're looking for their insurers for possible relief. So today's webinar is going to focus on one principal area, business interruption insurance, but there are other areas that are also implicated by the type of damages you see associated with coronavirus. And we're going to talk about some of those as well, including contingent business interruption and political risk insurance, and even cyber liability insurance. Beyond that, though, in some topics that we really won't have time to delve into today, there are businesses that are going to be sued, for example, for allegedly causing personal injury. Think of somebody who's on your premises and believes that they contracted the virus while at your store or your restaurant or your facility. There's the possibility of personal injury lawsuits that are going to result. And your typical general liability policy may or may not cover claims alleging personal injury related to COVID-19. There are businesses that are in the event planning or event space, and there have been cancellations. Think about concerts or sporting events, conventions, any type of business that revolves around bringing people together. Obviously, they've been dramatically impacted by COVID-19 and by the governmental shutdown. There are specific policies that relate to event cancellation, and many people who sponsor those events or involved in those events will have that, and there are clearly going to be claims presented under event cancellation policies. That too is beyond the scope of what we're going to talk about today, but something to keep in mind as one line of coverage that's out there that might apply in this situation. I have no doubt there will be an onslaught of securities cases filed against officers and directors claiming that they should have disclosed more information about the impact that coronavirus has on the business. There's already been several lawsuits brought against cruise lines. And the allegation there is that the officers and directors knew and should have disclosed that this global pandemic was going to have a dramatic impact on that business. D&O insurance policies may step in and cover in a situation like that. So if you think most broadly about insurance coverage, insurance policies, there certainly are a host of different areas that are implicated by liability and loss associated with COVID-19. But in the interest of time, we're going to focus on those areas I mentioned before, and in particular, business interruption insurance. We're going to walk you through the basics of what business interruption insurance coverage is. We're going to talk about issues involved in making a claim for lost income or other expense under a policy that covers business interruption. And then we're going to give you some recommendations, some practice pointers on what policyholders should be doing to make sure that they're protecting and asserting their rights to coverage under these policies. Joining me today, as Dale has already mentioned, are my colleagues in the Insurance Recovery Group at McGuire Woods. Matt Fender is a partner in our Richmond office, and Dorset, counsel in our Charlotte office. They're going to be talking about some of these issues, and we'll kind of go back and forth to cover these as we go along. Each one of us as Dale has already explained, have extensive experience representing policyholders in insurance recovery matters, including business interruption claims. And it's a little bit of a full disclosure item. McGuire Woods insurance recovery practice is on the side of the policyholders, to be clear. This is a presentation that's intended to be even-handed and to address the issues in as objective a way as we can. I don't want anyone to misunderstand, however, that when we represent clients in insurance recovery matters, we're representing the policyholders. So sure, yeah, we have a stake here, and we probably even have a bias on how these coverage issues should be resolved. But if you put that in your back pocket and understand that as you hear your presentation, I would tell you we're going to try to give you what I think is a fairly even-handed presentation on what these issues are. So with that wind up, I'm now going to pass the mic on to Matt Fender, who's going to talk to you about some of the basics of business interruption insurance.
Thanks, Steve. So, big picture, there are a lot of folks who have never heard of business interruption insurance before March of this year, or if they heard of it, didn't know anything about it. So I'm going to kind of take you through the broad strokes. The first thing to know is that while there are certainly specialty policies available, the basic business interruption insurance is included as part of a typical commercial property policy, which is to say the same policy that you buy to protect yourself against your building burning down or being destroyed in some natural disaster or incurring some other kind of damage like that, your sort of typical all-risk policy. Those policies almost always include some kind of business interruption coverage along with that. And there are some other coverages that are typically bundled together. One of those is mentioned here on the bottom of the slide, which is extra expense coverage. And the idea is your business burns down, the carrier is going to pay to fix the building, they're going to pay for the value of the personal property that was in the building, and they're also going to pay for other expenses you incur to mitigate and manage the risk. Like maybe you have to hire a security guard to guard the site because the building is no longer secure after the damage, or something along those lines. On the next slide here, we've got just an example of some policy language, and I'm giving you a couple of different examples from actual policies we've looked at of each one of the clauses that we're going to talk about. And the key point here, this one says, we will pay for the actual loss of business income. This is the related BI cover that you sustain due to necessary suspension of your operations during the period of restoration. The suspension must be caused by direct physical loss or damage to property. So your business has burned down and it's going to take you a while to fix it. That period of restoration is usually a defined term in the policy, but it usually just means something along the lines of the time that it takes to fix it. And so during that period, you're going to get coverage for your lost business income. Now, in terms of how that's calculated, it varies from policy to policy, but it's generally something along the lines of your net income, the money you would have made, plus your unavoided expenses, the fixed costs that you had to incur. But the key thing I wanted you to understand for purposes of what we're talking about today is this trigger for the BI coverage is direct physical loss or damage to property. Let's look at another one here. This is from another policy. And here it says business interruption loss is insured as a direct result of physical loss or damage of the type insured. So that sort of incorporates this question of what kind of risks are covered under that policy. And we're going to get back to that in a minute. Here's a third example. This policy shall cover the loss resulting from necessary interruption of business conducted by the insured, including all interdependent loss of earnings between or among companies owned or operated by the insured. And then here's in red, caused by loss, damage, or destruction by any of the perils covered herein during the term of the policy. So it again incorporates this same idea that it's got that the business interruption coverage only happens if the interruption to your business was a result of damage to property. That is probably not amazingly useful to us in the context of COVID-19, because if you have coronavirus contamination at your property, it's probably not going to take you a terribly long time to clean or disinfect it. There's all sorts of products and services available, and generally within a few days you would be back in business if that was the reason you weren't in business. The point here on this slide is that the question of whether COVID-19 constitutes physical damage is going to be the kind of the whole game on whether you can collect on that sort of stuff. So your property is infected with the novel coronavirus, and you've had to incur some expenses to clean or disinfect it, and you've been shut down for a few days as a result. Whether you can collect on that or not is going to turn on this question of whether the coverage trigger of physical loss or damage is met by the presence of the virus. What is probably more helpful to us, what is certainly more helpful to us in this context, is what's called the civil authority coverage extension. Now, again, almost all commercial policies, certainly all the ones I've looked at, have this. It's called a coverage extension. This is added on in addition to the basic business interruption coverage. You also have this additional coverage, and it's triggered when you lose access to your business premises as a result of a government order. So that's sort of exactly what has been happening as a result of the coronavirus. We've had almost all the states have issued orders which to one degree or another required businesses to close. And so this is what we're interested in. And what happens is the way that civil authority coverage works is it entitles you to the replacement business income coverage, even though there wasn't direct damage to your property. It's because there was damage to other property and the government ordered you closed. Here are some examples of those, and we'll sort of show you some of the differences here. This first one says, when a covered cause of loss causes damage to property other than property at the described premises being the part that's insured, we will pay for the actual loss of business income you sustain and necessary extra expense caused by an order of the civil authority that prohibits access to the described premises due to direct physical loss or damage to property within 1 mile of that described premises. So the way this works is you don't have to have any damage to your property, but if you can show damage to other property within 1 mile and the government closed your business as a result, then you're going to be able to get the business income and extra expense coverage, just as if your business was the one that had been, actually damaged. Now, there's some time limits on that. There's some other changes, but that's the basic idea. And these clauses vary as to a number of things, but one of which is how far away the other property has to be. 1 mile is fairly tight. Some will say 5 miles. Some will say 100 miles. Sometimes it's unlimited. Let's look at this next one here. This policy covers business interruption coverage loss incurred by the insured during the period of liability if an order of civil or military authority prohibits access to a location, provided such order is the direct result of physical damage of the type insured at a location within 5 statute miles of it. And one more, this is a broader one. This policy insures against loss resulting from damage or destruction by the perils insured against to the actual loss sustained for a period not to exceed 90 consecutive days when, as a result of a peril insured against, access to real or personal property is impaired or hindered by order of civil or military authority, irrespective of whether the property of the insured shall have been damaged. So this one doesn't have the express requirement of damage to other nearby property, but it does say that the order of the government has to be issued as a result of a peril insured against. So it still incorporates that question that there has to be some kind of similar peril that's there. And here's one more coverage. It happens when access to real or personal property is impaired by order or action of a civil or military authority in connection with or following a peril insured against. So again, that same sort of type of language. But what you'll notice is that all of these require the policyholder to show that there's a covered peril involved, whether it's the peril occurred at property that's nearby, or whether it's more general, just to show that the government order is a result of a covered peril, it begs the question of whether the presence of the coronavirus is damage sufficient to trigger the policy. Is it physical loss or damage? Is the presence of it a covered peril? And obviously we like the covered peril language more, but it is largely a legal issue of first impression. We don't know of any court that has issued a decision one way or another at this point definitively saying that the presence of coronavirus is sufficient damage to trigger a property policy and provide coverage under civil authority coverage extension. This is very much still evolving. So moving on to the next point, some policies do also have coverage extensions and endorsements that provide coverage for outbreaks of infectious disease. The ones we've looked at are generally limited if the outbreak started at the insured premises. And some of them may, provide some coverage if it didn't start there. But the ones we've looked at were primarily a situation where somebody's running, not a healthcare facility, a gym or an athletic facility, and they've got a steam room or something, and there's some kind of an outbreak. But these need to be read very carefully because they seem to vary quite a bit from policy to policy. Here's an example of one that talks about if a described location owned, leased, or rented by the insured has the actual, not suspected, presence of communicable disease, and access to such described location is limited, restricted, or prohibited by an order of an authorized government agency regulating such presence of communicable disease, this policy covers business interruption coverage loss incurred by the insured during the period of liability at such described location. So if you're, to continue the example, your gym or health club is shut down by the government because there was an outbreak in your steam room, then you're going to be able to get some business interruption coverage under this kind of policy, but it's probably not going to help you because it requires the actual, not suspected presence of the virus. It's not going to help you if the government shuts you down because of the presence of the virus in the community as opposed to at your specific facility. I'm going to speak briefly about exclusions. There's two exclusions that we're principally looking at with respect to these claims. Some policies have a virus exclusion. And I've given you some examples of those here. There's a few different versions of it floating around out there, but essentially it says something like this one: we will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganism that induces or is capable of inducing physical distress, illness, or disease. I don't think that the presence of one of those viruses necessarily, is the end of the issue, and I don't think you shouldn't bring a claim just because you have such a exclusion. But we certainly would like the claim better if the exclusion wasn't there. Here's another example of one that's very similar, key language in red. And one more, loss or damage caused directly or indirectly by the release, discharge. This is on to the pollution exclusion. So for the policies that don't have a virus exclusion, almost every policy has a pollution exclusion of some sort, and we have seen some examples of carriers trying to argue that the pollution exclusion prevents coverage for COVID-19 contamination. This seems like a stretch based on most of the ones that we have read. I have seen a few, though, that in the definition of contaminant of that which is excluded, they actually include virus as a contaminant, and so it does seem like the pollution exclusion might be more relevant. But typically there's this language you see on the screen here that there has to be a release, discharge, or dispersal. And we think it may be difficult for the carriers to prove that there was a discharge or dispersal. Somebody who's sick came into your business, and as a result, there's some coronavirus there. Or more importantly, with respect to the civil authority coverage, there's coronavirus in the community. There's likely to be a legal issue here on this question of dispersal, seepage, migration, et cetera. Those kind of words that are typically in the pollution exclusion. So I just want to mention that briefly, as that is the sort of thing that we're seeing. And with that, I'm going to hand it back over to Steve to talk about contingent business interruption cover.
Thank you, Matt. So that's a fairly high-level overview of business interruption insurance coverage. And what I'm going to talk about now briefly is what I consider sort of the cousin to business interruption insurance, and it's contingent business interruption. So if you think of business interruption insurance as potential cover for direct losses that you suffer because your business has been impacted. Your factory burns down and you're going to incur loss of income or extra expense as a result of that. But what if your sole customer's facility burns down? Now, that's not property damage to you, but certainly there's an interruption to your business because your only customer is now not doing business and not buying your product or services. So that's where contingent business interruption insurance, or as the slide says, supply chain coverage comes into play. And this is, again, it's a form of business income protection, but it's for losses that result from an interruption in the supply chain. And understand this can be upstream or downstream. It can be businesses that supply goods and services, products to your business, and that's not happening because of some interruption in their business. Or it could be your inability to sell your products and services and goods to someone else because of an impact to that buyer's business. Contingent business interruption is not always a part of business interruption insurance. One thing we will talk about in a little bit is to make sure you understand the full scope of your insurance coverage package. When you look at your business interruption insurance, you need to know, do I also have contingent business interruption insurance? And I think in particular in the context of the coronavirus, that's a potentially important piece of insurance coverage. If your business itself is not impacted, but clearly the people you do business with are impacted, then your only line of recovery may be CBI, maybe the contingent business interruption. So if you think, for example, about a business that caters to cruise lines, that supplies food, well, there's nothing to prevent that business from carrying on its business except that there are no cruise lines that are going out onto the water and buying their food. So, here's a pretty clear-cut situation where there's been contingent business interruption. If you have a policy that covers that, then you're in good shape. Of course, the facts will always be first and foremost, including what does the language of the policy say. This is an example of language that comes from a contingent business interruption part of the business interruption coverage, since it's essentially a subpart. And here again, you heard Matt emphasize several times the necessity of having physical loss or damage. Well, the same thing applies to contingent business interruption. It's not simply limited to situations where your business has been physically damaged or there's been physical loss. It applies to that entity in the supply chain whose business has been interrupted. You need to demonstrate physical loss or damage. In this particular case, of the type insured, to property of the type insured, at the premises of any of the following within the policy's territory. And this particular sample covers direct suppliers, direct customers, or direct contract service providers of the insured. But then also, if you look at subpart C to this provision, any company that is a direct or indirect supplier, customer, or contract service provider of those described in A above. So it really does extend to the entire supply chain. It's not simply your direct supplier or your direct customer, it's people in that chain whose business is impacted in a way that prevents you from carrying out your business and results in lost income or extra expense because of that. So this is a continuation of that provision that I was just mentioning, and it says business interruption coverage loss recoverable under this business interruption coverage extension is extended to include the following business interruption coverage extensions, and this one specifically covers civil or military authority. So as Matt explained before, if you have business interruption coverage that extends to the civil or military authority piece, and that's a good thing, and that's another potential avenue to recovery, and that applies to the contingent business interruption part as well as the business interruption. And the last coverage part that I want to talk about is political risk insurance. This is far less likely to be in an insurance coverage package than business interruption or even contingent business interruption. But nevertheless, it's something that you ought to be aware of. If you have political risk insurance, it may be a possible avenue to recovery for damages relating to COVID-19. Your standard policy defines political risk as an event causing or arising from social or political instability. Social or political instability within a given country which causes loss or expenses to the insured. And then it goes on to explain when that happens. But if you know anything about insurance coverage litigation, most of it has to do with interpretation of words or phrases or terms that may not have been clearly defined. And if you look at something like social or political instability, that's kind of a vague term. And the breadth of a term like that is something that you may be able to take advantage of in a situation where you claim it was the social instability, the political instability that caused my business to suffer lost income or extra expense. The political risk definition goes on to say that actual net loss, which is what you're entitled to recover, in connection with a political risk event shall include income loss, extra expense, and covered expenses. So those are the key elements of business interruption insurance or contingent business interruption insurance. They apply equally to political risk insurance. I think for those of you who are familiar with political risk insurance, I think you typically imagine it applying to your business in a developing country, for example, where there's a concern, a threat of expropriation of private property by a rogue government. But it's not necessarily limited to that. The language is broader than just that situation. And if you look at this particular definition, it includes frustration of contracts to which such insured is a party. So that's another one of those relatively vague terms, phrases in insurance policy that may provide some room to make a claim and ultimately have to be resolved by a court. The general purpose of political risk insurance is to insure multinational businesses, and sometimes they'll have territorial limitations, but oftentimes they don't. And I think folks in evaluating the potential coverage they might have need to think beyond just simply the traditional concept of what political risk insurance is about, and think about this country and things that are happening here. Many of you may be aware of the story that came out about these eco-terrorist groups who came up with this notion that cell phone towers were causing COVID-19, and there were towers burning in England and in China and Canada, where groups would go out and set fire to them because they believed that they were emitting the virus. Well, there's a situation where if your political risk insurance coverage is worded similar to what we've seen here, there may well be an opportunity for coverage. Anne, I think you are going to talk to the group about quantum of recovery.
Yes. So in addition to proving that there's a direct physical loss to property, one of the very important aspects of submitting a business interruption claim is the proof of loss itself. Submitting claims under a property policy is very, very fact-intensive and requires proof down to the last cent being claimed. It will be a negotiation, and you will need to have all of your ducks in a row. It's important to note that a lot of the coverages that we talked about, both in terms of business interruption and civil authority, have occurrence limits as well as time periods for which the lost income is covered. If you're relying on a civil authority to present your claim, you need to be aware when, how these rollouts back to normal are impacting your business. If you're in phase 2 and your business is allowed to be open, then when that order comes down, if you're relying on civil authority, that would be the end of your claim. You should be working hard to assemble all of your losses, all of the income losses, and you may in fact need to retain an accountant to help you with this. Extra expense, as Matt talked about previously, what we've seen in the COVID-19 situation is where businesses have to move their staff off-site to work from home. If you have to purchase equipment, including computers, that would be extra expense, in addition to hiring security guards and the like. This is an example of how one policy defines actual loss. So it is not exceeding the reduction in gross earnings, less charges and expenses which do not necessarily continue during the interruption of such business. So each policy is very specific and particular about how actual loss is defined. You will need to look at that definition and assemble your proof of loss, which you must submit under oath and affidavit in accordance with the definition of actual loss in your policy. As I said earlier, if you're submitting a business income loss, obviously the expenses are a little bit easier to track. We recommend that you track your expenses using specific COVID-19 accounting codes. This will help you assemble the expenses. You also need to show that the loss of income is a direct result of COVID-19 or civil authority. You would see that the policies often include an appraisal provision. Do not engage in appraisal unless both you and the insurer agree on what is covered, because you do not want the appraiser, whose job it is to value property or value lost income. His expertise, his or her expertise, does not lie in making a coverage determination. So do not engage in the appraisal provision. It is our recommendation that you not engage in the appraisal provision until such time as there's an agreement as to exactly what is covered. And now we go to COVID-19 specific issues.
Thank you, Anne. And at this point, just sort of taking a step back and reviewing what we've talked about so far, if we can distill the points that have been addressed by Matt and Anne and me, here are 3 principal questions that we have seen repeatedly in evaluating business interruption claims for our clients at McGuire Woods. First, there's this threshold question of whether the virus constitutes physical damage to property. Matt talked about this at length. It's the cornerstone for coverage here. It doesn't necessarily mean the virus ate your business, that there was some physical manifestation, but the exact parameters of what physical loss or physical damage means is going to have to be resolved in the courts. It's not going to be resolved by a policyholder who says it is, or an insurance company who says it isn't. Second, what's the scope of damages covered by the civil authority extension assuming that you have that present in a policy. And Matt gave you some examples that show territorial limitations, time limitations. You need to know how broadly does the civil authority extension go. And then last, there's this issue of the exclusions. Matt talked about the virus exclusion, the pollution exclusion. My personal view is that the pollution exclusion is not going to be an impediment to getting coverage for coronavirus in most cases. The virus exclusion is going to be a more difficult issue. Some of these virus exclusions would appear to apply directly to a fact pattern that we've seen. In those cases, obviously, it'll be an uphill burden to try to convince the insurance company that they should cover you. This is a excerpt from a reservation of rights letter that one of our clients received, and you can see the insurer took the position here on whether there was direct physical loss or damage that, in my view, is fairly restrictive. To say that there has to be deformation, permanent change in physical appearance, or other manifestation of a physical effect, I think is reading that definition too broadly. But again, it's an issue that in all likelihood will have to be resolved by the courts or arbitration panels, not by the parties themselves. Another specific issue we've touched on several times, notice. Without a doubt, giving notice to your insurer for potential business loss associated with COVID-19 is essential. Failure to give notice can very well result in forfeiture of your coverage. It's a state law issue, and laws differ from state to state, but there are some places where it doesn't matter. If you don't meet the policy restriction for giving notice, then you're not entitled to coverage. In other states, the insurer would have to show that they were prejudiced by the late notice. But why take a chance? Why mess with a potential forfeiture of coverage when it's a relatively easy thing to do to put the insurer on notice? These claims are going to be difficult to pursue in and of themselves. There's certainly no reason to make it any harder by submitting your notice in a way that the insurer will consider untimely. There's also this issue of proof of loss that Ann talked about. And oftentimes policies will set a specific time period under which you have to submit your proof of loss. Make sure that you meet that time limit, or at a minimum, get an extension of time so that, again, you don't lose your right to coverage because you forgot to meet a deadline, or you didn't comply with a condition in the policy. Couple things to keep in mind here. Some fact-specific issues. Voluntary business closures are going to be extremely difficult to place under business interruption coverage. You may have very good reasons for closing your store or shutting down your facility to protect the health of your employees or to protect the health of customers. Lots of good reasons to voluntarily curtail your business, but it's not going to make your claim for coverage very easy. So understand, if we have civil authority extension, that's great, but the basis for your business interruption has to relate to that, not to an altruistic decision on your part to curtail your business for the safety and health of others. People are shopping less. People don't want to get out and go to a restaurant. That's not going to be covered either. Business interruption is fairly narrowly tailored for specific situations, and it's certainly not going to be interpreted to cover a situation where there's a downturn in the economy, a downturn in business, and people are simply not spending as much money as they did before. As Matt mentioned earlier, if you have a situation where your facility, your physical plant has been directly impacted by COVID-19, by the coronavirus, and there's a need to shut down and clean and disinfect, that's, I think your strongest case for coverage. But as Matt said, it's a fairly contained loss in a situation like that. What we're talking about is broader income loss that derives from a business that's been severely impacted because of COVID-19. I will touch briefly on the state of litigation. There have been scores of cases that have been filed mostly by policyholders, but there are a couple situations where insurance companies have filed a lawsuit seeking a declaration of no coverage. But for the most part, policyholders have been filing claims in state and federal court around the country. I've lost count. There are well over 60 individual lawsuits. There are some class actions that have been filed. It will be very difficult to maintain a class action in this area, but this concept of having some kind of coordinated or consolidated proceeding to deal with business interruption coverage disputes may be getting some traction. There's a couple of petitions for multi-district litigation treatment of cases in federal court. There are some obstacles to that since you have different insurers with different policy language, but I think there is generally a recognition that we just can't fight all these one-on-one, that there needs to be some kind of coordinated, consolidated treatment of business interruption claims. That dovetails well with what Matt is going to talk about on the next slide.
Thanks, Steve. Yeah, so the other sort of piece that dovetails right up against that are some legislative efforts that we have seen. Obviously, insurance is generally a question of state law, and the state legislatures have the power to change that law. But as an initial matter, there was a fairly high-profile letter that was sent by some members of Congress back in March to some insurance industry trade groups, essentially saying, hey, we'd really like you to cover these claims. The response in the insurance industry was not enthusiastic, and I don't think anyone was swayed by that letter, but it certainly showed us that there are people in the political branches of government that are thinking about this, and who, at least at that time, and I think still now, were looking to some kind of insurance recovery as part of the puzzle of the total solution and how businesses could weather the COVID-19 crisis. We haven't seen anything at the federal level, but what we have seen are in quite a few states. I listed New Jersey, Massachusetts, and Ohio on the slide here, but I think it might be up to as many as 10 states now. Some member, at least, has introduced a bill to require carriers to cover these coronavirus BI claims under existing policies. And usually it says, as a matter of law, says presence of coronavirus is direct physical loss or damage, and then it will often have something that voids the virus exclusion. Now, many of those bills are designed to apply only to small businesses. Sometimes there'll be a cap written in about how many employees the business can have or something like that. We haven't seen any of these pass yet, and of course, the fact that a bill has been introduced, all that really means is that 2 members of the legislature usually were willing to sign on to it. So it doesn't mean there's some great sea change out there, but it does reflect, I think, the fact that people in the government at various levels are thinking about business interruption insurance for the COVID-19 situation. And there's been a fair amount of speculation in the insurance industry certainly on the policyholder side, that we might see some kind of a bailout situation where the government requires carriers to cover this stuff, but also throws in some money and backstops the carriers to some extent in order to make that happen. Haven't seen anything hard on that yet, but there are some legislative efforts underway, and we're going to continue to monitor those. And with that, I am handing over to Anne. Anne?
Sorry. We're pivoting from property policies, and we're going to talk about cyber liability policies. This is a separate policy. While some property, some D&O, some E&O policies have limited cyber risk, if you have any of these risks, please consider whether having a standalone cyber liability policy would be effective to manage your risks. Cyber risks include denial of service, human error, which is still number one with computer problems, malware, extortion, and the like. With respect to what we're seeing with COVID-19, we're seeing the impact of COVID-19 is seen with the increased use of the Internet of Things. If you think about your Nest or your Alexa from the residential standpoint, but IoT is also involved with a lot of businesses. It controls thermostats, it controls machinery. Can be very easy to hack. With moving people from secured offices to home, you also face the risk of potentially moving them into an unsecured VPN. Remote operations, including the use of personal devices. People are now using their iPads instead of business issued computers. Remote meetings, we've all seen the news about Zoom and Microsoft Teams meetings being infiltrated. And social engineering. And social engineering is really one of the biggest threats right now. Particularly what we've been seeing scammers do is have work from home updates that are not in fact from the business owner, COVID-19 relief links, and updated payment information that purportedly goes from one company out to its customers, its purchasers, and saying, oh, we are changing the payment information, please now use this form. The impact of social engineering hit Honda. On Friday, Honda announced that its internal systems had been infiltrated by the eCans malware, which shut it down completely. It took Honda several days. I have not been able to confirm that all of Honda is up. I know it took at least 3 days to get U.S. operations up, and they believe that it came exactly from a COVID-19 link that was sent to one of the employees who clicked on it and let the malware in. In addition, the Nintendo experienced a breach and recently stated that instead of the 160,000 accounts, more than 300,000 accounts had been hacked. And then on Friday, the city of Florence, Alabama, email system was shut down by ransomware thieves who demanded $300,000 to release the email report. And you can feel sorry and feel bad and understand what that city was going through as they're scrambling to address other issues. Even though they were advised, they just did not have the time or the wherewithal to address the malware that was in there. And according to news reports, the city has agreed to pay the ransom. So the good news about cyber insurance is, and then here's the increase in claims. You can see from 2017 to 2018, more than 10% increases for malicious insider, denial of services, web-based attacks, and malware. So cyber insurance has two sections to it. It has the third-party section and it has the first-party, which is what we'll be mainly focusing on, but I did want to alert you to some of the key functions that are provided under the third-party cyber coverages, and that includes government and regulatory investigations, management liability, and cyber-induced property damage. First-party cyber coverage, and this is where you find the business interruption coverage. Often it will be called system failure or business interruption, business income. And unlike your property policy, physical damage to the building, to the bricks and mortar, is not required. But what is required is that your system completely fails. So if you think of the recent malware attack on Honda, their entire systems were shut down across the board. So that's where cyber insurance will come into play. Here's one definition of system failure. And you can see it includes an unplanned outage or interruption and could be caused by a hacking attack. This one was written to a policyholder that had EU businesses, so this third one is specific to companies that are practicing, that have business in the EU. Steve had talked about contingent business interruption in the property policies. There's also contingent system failure coverage. This is not necessarily in all policies. This is an enhancement. But it is important, particularly if you are, for example, if you are storing your information on a cloud and the cloud operator goes down, you get hit with your losses because now you can't retrieve information. This is where your contingent system failure coverage would come into play. As I said, it's relatively new, and I want to also point out that both contingent system failure coverage and system failure coverage often have waiting periods. So what that means is your system goes down, and the most common is you have 12 hours to fix it. If you cannot fix it within 12 hours, then your losses begin. They also have time periods. Some policies will limit the amount of time that they will pay for losses to a few days or a few weeks. These are all negotiable terms, so it's something that you need to keep in mind when you're sitting down with your broker to talk about cyber insurance. So the cyber insurance market is incredibly dynamic. As I said, they've recently started providing contingent system failure coverage. Coverages are growing and the number of insurers providing it are growing. However, the more enhancements to this coverage you want, you have to show that your entity is being managed at the front of the bell curve. So premiums, it is not an inexpensive product. We've been seeing $10,000 to $40,000 for $1 million worth of coverage. That will go up if you add some of these extensions. Currently, the most common limits are still within $1 to $5 million. This, again, is something that you need to look at your enterprise and the risks that are presented to your enterprise to determine whether you would need to get excess insurance above that. Companies who really should be thinking about that are companies who handle PPI, CCI, which is private personal information, credit card information, and HIPAA information. If you commonly carry that kind of information, you need to consider whether the 1 million to 5 million is sufficient. So it's always our recommendation that you work with experienced professionals, as I said during my presentation, and I'm very cognizant of time, so I'm going quickly through the slides. You really need to work with experienced professionals. This is a highly specified market. If your current broker is not that savvy with cyber insurance, we recommend that you consider working with a broker solely on cyber who is familiar with cyber, because there are so many variations to the policies and the coverage. You need to identify your company's unique risks, and you need to understand what you need and buy what you need, because you don't want to be overinsured, but you also don't want to be underinsured. Some of the current common policy limitations include the restriction of the choice of counsel, also a restriction of choice of consultants, including IT consultants and what I'll call public relations consultants. To me, that's not necessarily a bad thing. The insurer will tell you exactly who you have to call, and you call them the minute a problem arises. The consultants are typically nationally known, nationally renowned, and they all have the same goal, which is to fix the problem as soon as possible, to restrict any damage as much as possible, and to get you back up and running. Also, these policies have numerous retentions and sublimits. A lot of that is negotiable, so that's why you need to work with somebody who can help you identify your risks and determine whether you need a little bit more insurance on some of these sublimited provisions. As with property policies, there are strict notice requirements, and you are not, and restrictions against voluntary payment. You may be able to, and that means you have a cyber event, you immediately go out and do these things before you put the insurer on notice. Some policies will limit that that amount of time and those efforts very specifically. So you need to pay attention to those provisions. So what we want you to do is to get the most out of your premium and to negotiate. And again, this goes back to my prior advice of understanding what your risks are and working with someone who can help you identify your risks. But these are some of the things that could be excluded or could be additional coverage that you may or may not need. One that I really want to focus on is prior acts or claims. If you are new, if you have not purchased cyber insurance, it is always a good idea to try to get prior acts or claims coverage. That means you buy a policy today, last month you did not know it, but a spammer got into your systems and now you find out that some PPI has been released. If you don't have a look-back period, if you don't have prior acts or claims, then you would not have coverage for that. So for those who are new, who are buying the policy, look into that. In addition, if you're acquiring a new entity within your system, it's important to get prior acts coverage for that entity, and it is available. Again, these are things that we want you to look at when you're negotiating, whether it's for renewal or for initial purchase. If you have a lot of employees who are using mobile devices, there is specific coverage now available for that. If that presents a risk, particularly, for example, if those employees are able to access PPI or HIPAA information, you should consider purchasing coverage for those devices. And then follow through. And as with your regular insurance program, you need to sit down and think about what insurance you need, not only for your property and general liability, but also for your cyber coverage. You need to be able to integrate your coverage with the impact of what a breach would have on your businesses. And now we've come to the end of our presentation. Steve, back to you.
All right. Well, thank you, Ann. We just wanted to end the conversation with a few recommendations for those of you in the audience who are policyholders. You know, this is for you. There are a couple things that we just believe are essential, and first, in a sense, this is pretty obvious, but you need to do a fulsome review of your insurance coverage program. I've mentioned this before. Unless and until you do a thorough review of the policy language, it's impossible to know what kind of coverage you have and don't have. And some of this is pretty dense and pretty difficult to understand. If you don't have in-house insurance expertise, there are experts on the outside who can take a look at your coverage, people with experience in the coverage field, who can provide you with a sense of what you're entitled to, what you're not entitled to, so we can move forward with a better understanding. Second point, something Ann I talked about before, identifying losses and beginning to track losses. In the business interruption area in particular, this is vital. It's all about being able to prove your damages. The insurance company is going to look for proof. It's going to look to validate your alleged damages. The sooner you start tracking those, the better off you're going to be when it comes time to make that proof to the insurer.
Yeah, so our third point, this is Matt, to understand your coverage situation and add it to your analysis when making business decisions. And the coronavirus situation and the possibility of business interruption claims related to that really brings this right to the forefront, right? It's typical for a business to buy insurance. Maybe a big business has a full-time risk manager, but it's not always the case that the people making the business decisions, leading that business, have a fulsome understanding of what the coverage is available and how those insurance assets can be used to help the business, particularly in time of crisis. So I encourage you to take a look at that. If you don't have somebody in-house that can help you understand your coverage, reach out to somebody who can. And that, of course, flows naturally into the next point about your broker and or agent. We love our friends in the brokerage community, and they often have a good understanding of how this coverage works. So certainly talk to them, but also understand that because they're not litigators, they may not be the final word in how coverage can be pursued and what's really available once the loss has occurred. Ann?
Thanks, Matt. So it is our recommendation that if you have suffered business income loss as a result of COVID-19, that you provide notice to the insurer in order to reserve all rights under your policy. As we've said at the outset, this is an evolving question. It is going to be a battleground. It is not something that's going to be easily won by either side. Anyone following COVID-19 and how and the science behind it will understand that this is not a simple issue, but you need to provide notice in order to reserve all of your rights under the policy. And then when you receive a response from the insurer, you need to respond to those letters. And you need to start preparing your proof of loss. So all of these things you can do even given a very uncertain situation. And now we're going to, I don't know that we have time for questions, and I apologize for that. But if you've submitted questions, we will definitely respond to them by email. And I hope that you all enjoyed our presentation. It was, and look forward to any questions that you may have.
And the questions we had concerned the possibility of legislation. And I think those were covered, as well as the idea that certain employers may or may not be particularly at risk by return to work. Could you talk about that for just 1 second?
I'm not sure I understand the question.
Sure. What do you think, or have you even seen, Matt, Steve, in any other states, attempts at legislation to implicate coverage, get around coverage, provide additional benefits similar to the kinds of relief provided by the payroll protection program? Have you seen anything around the country yet? And if so, where?
So this is Matt. The one thing I can say is I know there's been a fair amount of legislation introduced, but none passed to my knowledge, both at the federal and state level, to try to provide some immunities for businesses that are reopening from a coronavirus liability standpoint. So, to continue the earlier example, if you have somebody who operates, a fitness center or a health club or maybe a movie theater, they would like for the legislature to pass a law saying that they're immune from people suing them claiming they caught the coronavirus at their facility, right? Because that's now a big risk that they had not previously had to deal with, that they would like to not have to deal with. Now that sort of would implicate not the property insurance we've been talking about today, but probably your commercial general liability insurance. And it's going to be a policy-specific question as to whether that's going to be covered. Is there some kind of virus exclusion tagged on to those policy forms? If there's not now, I suspect there's going to be in the renewal unless you pay a pretty big premium for it. So that's one thing that we certainly have seen floating around out there. I don't know if that answers the question.
It certainly does.
And another...
Sure.
Another thing that we've been helping clients with, such as schools and camps and things like that, are drafting waivers. That is very state-specific as to whether a state will uphold them, but that is one way that you can limit your exposure is through a waiver of liability forms.
That's a really good point, Ann. Thanks for bringing that up. Hey, listen, we've run a little bit over time. Ann, Matt, Steve, thanks for joining us. I'd like to ask listeners to join McGuire Woods and Ramble Consulting on June 17, 2020 at 2 o'clock in the afternoon Eastern Time, be 1 o'clock Central Time, for a really focused discussion and industry outlook on air permitting of data centers in the U.S. The McGuire Woods Data Centers and Environmental team, along with Ramble, will present on the growth of data centers in the U.S. Our discussions will highlight air permitting and compliance efforts and some recent developments taking shape across the country. You might be surprised to find out that if you've already ordered a generator to put on site at any facility, and this is not specific to data centers or the internet infrastructure industry, that you may already be in non-compliance. If you'd like to hear more about that and how to solve that problem, join us next week, June 17th at 2 o'clock Eastern Time. That's 1 o'clock Central Time for internet infrastructure issues. Steve, Ann, Matt, thanks again. Gregory, good to have you here with us today.
Thanks, everybody.
Thank you.
See you next time.